to entertain the suit. The counsel on behalf of plaintiff respectfully submit that yes, the Honorable Civil Court has jurisdiction to entertain the suit. The counsel will address the issues from four aspects. Firstly, Your Lordship, legal provisions establishing the jurisdiction of this Honorable Court. Your Lordship, Section 16 of Civil Procedure Code grants territorial jurisdiction to Civil Court, which states that suit related to immovable property must be filed in the court within whose jurisdiction the property is located. Since the disputed project Green Meadow Residency is located in Islamabad, therefore this Honorable Civil Court of Islamabad has territorial jurisdiction to entertain this suit. Also, Your Lordship, Section 6 of CPC grants pecuniary jurisdiction to this Honorable Civil Court. Section 6A of Civil Procedure Code Civil Procedure Code Amendment Act 2019 grants pecuniary jurisdiction to this Honorable Court, which states that Civil Court has jurisdiction to entertain all suits where the monetary value is less than 50 million rupees. Since the amount in question is PKR 30 lakhs, hence it falls within the pecuniary jurisdiction of this Honorable Court. Also, Your Lordship, Section 9 of CPC provides that Civil Court has jurisdiction to try all suits of civil nature. Your Lordship, since the present suit pertains to breach of contract, refund of payment and compensation, all of which are civil matters, hence this Honorable Civil Court has jurisdiction to entertain this suit. Secondly, and most importantly, Your Lordship, I am requesting your attention to last para on page number 15 of the memorial. Your Honor, the word may is used for arbitration and contract of sale between the parties, not shall. Hence, Civil Court is not expressly barred from hearing the case. Your Honor, a case law of Karachi Dock versus Quality Builders Limited is clearly supporting the stance of plaintiff. I am requesting the bailiffs to please provide the copy of judgment to the honorable judges. Your Lordship, in this case law, having titled Karachi Dock versus Quality Builders Limited, it was clearly held that the intention of the parties to refer the dispute to arbitration can be inferred through the language used in the document. Hence, in the present document, which is arbitration agreement between the parties, the word may is used, not the word shall. Hence, according to this case law, this Honorable Civil Court is not expressly barred from hearing the case. Thirdly, Your Lordship, the nature of relief sought. The plaintiff is seeking injunction and damages, etc., which are beyond the scope of arbitration and need the intervention of civil court. Hence, this Honorable Civil Court has jurisdiction to entertain the suit. Your Lordship, another case law having title K Electric Limited versus Federation of Pakistan is also supporting the stance of plaintiff. Your Honor, in this case, similar issue has been raised. The Honorable Civil Court rejected the application and held that sufficient reasons have been shown by the plaintiff for not referring the present matter to arbitration. The Honorable Court also held that the suit must be allowed to proceed and be heard and decided on its own merit, and the application was dismissed. Your Honor,
जो this PLD 2014 से 504 ये आप कर लें इसको पढ़.
Your Honor, in this
the matter must be referred for arbitration.
Your Honor, another copy is not available with me. In this case, the Honorable Court held that whether suit should continue in the present arbitration agreement or whether it should be referred to arbitration council. The court held that the prima facie, whenever an arbitration agreement exists, the matter must be so referred to arbitration. So, Your Honor, the point to be noted is this point was raised by the defendant counsel. The Honorable Court rejected this application and held that the matter shall be continued and be heard by the court. Your Honor, page number last, the Honorable Court rejected this application.
Yeah.
Thank you, Your Lordship. Your Honor, another case law having title Pakistan International Airlines Corporation versus Misris Pakistan is also supporting the stance of plaintiff. In this case law, similar issue has been raised, Your Honor. The Honorable Court also held in this case that the mere existence of clause providing for arbitration does not bar a suit or other legal proceedings in court. It only entitles a party to have the legal proceeding stayed, and in order to stay the legal proceeding under the arbitration clause, application under section 34 has to be filed by the defendant before filing of written statement. Hence, Your Honor, written statement is already filed by the defendant, hence they cannot claim the stay of suit under section 34 of arbitration. If the Honorable Court is satisfied and there is no further question, may I proceed toward the next issue? Much obliged. Your Honor, the issue number 2 framed by the Honorable Court is that whether the defendant Ali Raza committed a breach of contract or not. The counsel on behalf of plaintiff respectfully submit that yes, the National Real Estate Corporation do committed a breach of contract by failing to obtain the necessary environmental clearances for Green Meadows Residency project. The counsel have 5 submissions in this regard. Your Honor, firstly, that how NREC committed the breach of contract. Your Honor, according to clause 3, para 4 of the contract between the parties, the defendant is responsible to obtain all environmental and regulatory approvals within reasonable time. Despite passing of 12 months, NREC failed to obtain environmental clearances. Hence, NREC breached the contract. Also, Your Honor, according to clause 3, para 5 of the contract between the parties, the defendant was responsible that if government imposes restriction or halt the project due to regulatory approvals, the seller shall inform the buyer within 7 days. Your Honor, NREC also failed to inform the buyer through a written notice within 7 days. Hence, he also breached this clause of contract.
Where is the limitation of 7 days?
Your Honor, it is situated on clause 3, para 5 of the contract between the parties. Your Honor, the contract between the parties is attached here. Clause 3, para 5. Your Honor, it was clearly written in that clause in para 5 that the defendant shall inform the buyer within 7 days through a written notice if the government halt this project, and NREC failed to issue a notice to Ali Raza, hence NREC breached the contract. Thirdly, Your Lordship, my submissions will be the legal provisions which has been violated. Your Lordship, I will be requesting your attention to page number 19 of the memorial. Your Honor, first of all, Section 37 of the Contract Act has been directly violated by the National Real Estate Corporation, which states that the parties to the contract must perform their respective promises. Hence, NREC failed to issue the notice and obtain regulatory approval within 7 days. Hence, he directly violated Section 37 of the Contract Act. Also, Your Lordship, the point to be noted that the defendant NREC also violated Section 19 of Islamabad Real Estate Regulation and Development Act 2021. Your Honor, Section 19, Clause 1 of the Islamabad Real Estate Regulation and Development Act bound the seller to inform the buyer about everything which is written in the contract.
What reliefs have you sought in your plan?
Sir, we have sought 3 kinds of relief. Firstly, a full amount of refund as he breached this contract. Secondly, Your Lordship, we are seeking additional damages for several reasons, such as his money was stuck in a stalled project. If it was not stuck here, he may invest it in any other project which would earn him a great amount of money, Your Lordship. If the Honorable Court...
You haven't sought any relief like specific performance of the contract, because this thing is based on the whole issue is based on a contract. So why
Yes,
don't
Your
you
Lordship.
ask specific performance of the contract whether the defendant is still willing to perform his part or not?
Much obliged, Your Lordship. Your Lordship, as I already discussed, that plaintiff has been suffered by various damages, such as he has been suffered a heavy amount of litigation cost. Also he has been suffered by the opportunity cost. So your lordship, we are seeking, and also the defendant clearly breached the contract. That's why we are seeking our refund.
Why directly the damages and injunction? Why not the specific performance is the question?
Much obliged. Your lordship, the counsel is ignorant of this fact. I will be addressed this later. If the Honorable Court allowed, we may proceed toward the issue number 3. Much obliged. Your lordship, the issue number 3 framed by the Honorable Court is that whether the plaintiff right as consumer has been violated or not. Your lordship, the counsel on behalf of plaintiff respectfully submit that the question of consumer right is secondary to the main cause of action, which is breach of contract. The plaintiff has approached this Honorable Court not as a consumer but as a contracting party whose right has been violated. Your lordship, I have 2 submissions in this regard. Firstly, the plaintiff is not claiming consumer right violation. We are claiming breach of contract, as the cause of action is purely contractual, as we are claiming a refund of amount, compensation and injunction. So your lordship, my second submission in this regard is that the court has authority to make a determination on consumer right violation. If this Honorable Court determined that our consumer right is also violated, then we will also have an opportunity to file a consumer case separately.
Okay, how much additional compensation have you mentioned that you want in this case?
Thank you, much obliged, Your Honor. And the plaintiff, we have not mentioned any specific amount, but as the Honorable Court may deem fit, that compensation shall be
You
allowed.
have mentioned that he suffered some mental anguish and financial loss.
Yes,
So,
Your Lordship.
Prove mental anguish.
Much obliged, Your Lordship. Much obliged. Your Lordship, the later 3 issues will be addressed by my co-counsel. Thank you.
Thank you, Your Honor.
As per I, why not specific performance? Prove mental anguish and why you haven't mentioned the amount for additional compensation or damages, which are.
Your Honor, firstly, the specific
There is a
performance.
consequential relief that we have sought. What is also.
Your Honor, the specific performance is not claimed by my client because the defendant has explicitly breached the contract, and due to the breach of contract, it has caused me financial losses because I have paid the rental expenses of my residence because the possession was not delivered on time to me. Second, I have opportunity cost. If I have invested this amount in an alternative property, then I could have generated income from that property, and the possession of the same will be delivered to me on time. Now, Your Honor, coming towards the mental torture, Your Honor, there is a case between Miss Irshad Jaha versus PNSE 1999 CLC 192. In the present case, the plaintiff has suffered mental stress. Same was suffered by the plaintiff, who was removed from service, and she claimed mental torture. In this case law, the Honorable Court held that damages for mental shock and torture fell in category of general damages, for assessment of which no definite method was laid down. Primary consideration of the court in such cases should be to compensate plaintiff so far as possible for injury caused to them. So, Your Honor, according to this case law, the mental torture needs no proof. This can be proved according to the text.
Contract for other contract. इसके कॉन्ट्रैक्ट में जो आपने मुझे क्या हुआ है सिविल रिप्रेजेंटेशन एंड और चीज़ की है इनमें से
Your Honor, the fourth issue is whether the defendant can invoke the force majeure clause in order to justify the delay in fulfilling its contractual obligation. Your Honor, no, the defendant cannot invoke the force majeure clause, and the defendant reliance on the force majeure clause is unjustified. Your Honor, I have several submissions regarding this stance. Your Honor, my first submission is about the class 6 of the contract set, which contains force majeure clause. Your Honor, it states that neither party shall be liable for failure or delay in performance under the contract due to circumstances beyond their control. So, Your Honor, in order to invoke this clause, it is necessary condition that the circumstances must be beyond their control. Obtaining environmental clearances are not beyond the control of the defendant. It was due to the negligence of the defendant. Your Honor, if you look at the facts of the case, the defendant has filed the compliance report on dated 28th February 2023, and the CDA has issued notice on dated 1st February 2024. Your Honor, it has a gap of 11 months and 10 days. During this gap, the defendant has not addressed any query from the EPA, nor filed any application before the EPA to obtain updates about the delay. Your Honor, it clearly shows the negligence of the defendant. Moreover, Your Honor, if you look at the notice of the CDA, in the notice of the CDA, it is clearly written that the defendant must do compliance within 30 days by getting the approvals which are pending before the EPA. Your Honor, the defendant has not done anything about this, nor do any compliance of this notice. So, Your Honor, it clearly shows the negligence of the defendant. Now, Your Honor,
you are talking about the force majeure or the negligence?
Your Honor, in the contract act.
सर वो नेक्स्ट क्वेश्चन है लेकिन अगर ये डिफरेंशिएट करना चाहें तो अलग
Yes.
कर सकते हो दोनों इकट्ठे भी हो सकते हैं
ये फोर्स मेजोर का जो क्लास आपने नोट किया हुआ है तो इसका फैक्ट्स में एक्चुअली क्या हुआ था
Your Honor, the force majeure clause is added in the contract parcel at the time
So
of
what
execution
happened?
of contract.
What happened?
Then Your Honor, the defendant has taken the stance that I have the force majeure clause, that I can, defendant says that I can invoke the force majeure clause to justify the delay in getting environmental clearances. Your Honor, but my stance on this issue is that the defendant cannot invoke the force majeure clause because the circumstances was not beyond the control of the defendant. It was due to the negligence of the defendant. So I have proved the negligence of the defendant from the facts of the case. Now, Your Honor, coming towards the onus of proof, it is general principle of law and jurisprudence that whoever takes the shelter of general exceptions like force majeure, he has to prove general exceptions. Your Honor, it is now upon the defendant to prove that he has acted in good faith. He has acted in good faith, and getting the environmental clearances was beyond their control. Your Honor, now coming toward, with due permission of the court, may I come towards the fifth issue? Whether the plaintiff Ali Raza is entitled to claim damages beyond the refund of the amounts paid, including compensation for financial and personal losses allegedly suffered as a result of the defendant's breach. Your Honor, as already discussed by my co-counsel, that the defendant has explicitly breached the contract. Now, Your Honor, the plaintiff is entitled for the refund of the amount along with the damages because my client has suffered financial losses and emotional stress. Financial losses includes the rental expenses, opportunity cost, and cost of litigation. And the emotional stress is also caused due to the dependence breach by way of managing both the house rents and the plot installments, and the uncertainty about the project's completion. Now, Your Honor, coming toward the legal basis on which I claim these damages. Your Honor, Section 19 of the Specific Relief Act empowers the court to grant compensation grant compensation in a case of breach of contract. Your Honor, Section 73 also establishes the right of an aggrieved party to claim damages for the losses caused by the breach. Your Honor, coming towards the case law. Your Honor, as the present case, the plaintiff is claiming damages for emotional distress. Your Honor, same was claimed by the plaintiff in the case between Ms. Irshad Jaha versus PNSE, reported as 1999 CLC 192. It was held by the Honorable Court that damages for mental shock and torture fell in category of general damages for which no proof is needed. With due permission of the court, may I proceed toward the sixth issue? Much obliged, Your Honor. Your Honor, the sixth issue is whether the plaintiff individual claim for damages should take precedence over or be considered in conjunction with the potential claim of other buyers. Your Honor, the plaintiff individual claim for damages should take precedence over the. My first submission is regarding the doctrine of privity of contract. Your Honor, the contract was directly breached against Ali Raza, which gives him a right to individually file a suit. Your Honor, in contract law, the persons who are parties to the contract can claim to the breach of contract. Your Honor, as NREC enter into contract with all buyers separately, so a separate suit must be filed for the breach of contract. Now coming towards the doctrine of privity of contract, which says that contractual obligations and rights are specific to the parties to the contract. Your Honor, means that a person who is not a party to the contract cannot take the benefit of it. Your Honor, my submission before this honorable court is that the plaintiff Ali Raza is entered into the contract with the defendant separately, so the suit must also be filed separately and entertained separately. Your Honor, now coming towards my second submission, which is about the personal financial impact. Your Honor, the plaintiff losses are unique, means that they are different from all other buyers. So, Your Honor, it is necessary for the court to entertain a suit separately. Your Honor, now coming towards my third submission, which is right to timely justice. Your Honor, if the plaintiff claim is adjudicated along with all other buyers, it will compromise the basic maximum of equity, which is justice delayed is justice denied. Your Honor, if the plaintiff claim is adjudicated along with all other buyers, it will also compromise the fundamental right of the plaintiff, which is available under Article 10A of the Constitution of Pakistan, which is right to fair trial.
Out of connection with the contract, the two parties will be going towards the negotiation. If negotiations fail within 30 days, the either party may move towards arbitration. And here the plaintiff totally ignored that section of arbitration clause 1940, and the venue should be Islamabad. Your Honor, it is mentioned in clause 8 of the agreement. Your Honor, there is citation of 2005 SMRC 1782. I am requesting to the left kindly submit there. Here on.
Can we get the copy of agreement?
Here is. Your Honor, there is citation of Supreme Court Judgment 2005 is MRC 1782, where the Honorable Supreme Court held that the arbitration clause of a contractual agreement the plaintiff was required to approach the arbitrator, and it was the only remedy available to him. And here, Your Honor, the plaintiff totally ignored the arbitration clause and directly filed this suit in the civil court. Your Honor, here is the another in section 9 of Civil Procedure Code. Here it is stated that if any explicitly or impliedly agreement are not mentioned, then the civil court has the jurisdiction to listen or to listen the suit. But here it is explicitly or impliedly mentioned in the clause 8 of the agreement that if anything is happening between the parties, the first we will be going to solve that problem to negotiation within 30 days, and if negotiation fails, then we have the other option, that is the arbitration. Here the plaintiff ignored that clause. Your Honor, here is another thing is that here the plaintiff ignored also the consumer court, which he is claiming that here the violation of consumer court. Here the consumer court is also available.
They are consumer.
They are claiming.
In this case, they claim that we are a party to a contract. We are not a consumer.
Yes, sir. Your Honor, they are claiming their consumer right has been violated.
Whether they are consumer, can you define consumer in this case?
Your Honor, but they are claiming their consumer right has been violated. That's why they have another option to file the suit in consumer court rather than come to the civil courts.
For a contract like this one, should we file a suit in consumer court?
Your Honor, there is a issue in third number issue that third number issue that their consumer right have been violated. If their consumer right have been violated, they must go to the consumer court, Your Honor, not to the civil court. Your Honor, I am granting the permission to move towards the issue number 2. Your Honor, the second issue is whether the defendant in REC committed a breach of contract by failing obtaining the required environmental clearance, thereby acting negligently. Your Honor, the NRC has not committed any breach of contract. The contract specifically class 3 clearly addresses the vicarious regulatory approvals of time which they were signing the agreement. All the requirements were clear except in the contingent. There was a contingent clause in the class 3 of the contract that there is only the environmental clearance certificate is remaining, which the NRC was trying for that, and they are already submitted the application submission of initial application environmental clearance application and the subsequent compliance with EPA recommendation, and another the re-application of environmental clearance, and the EPA teams were also visited there. Your Honor, there is the furthermore, my Lord, under the doctrine of COVID intern, that let the buyer be aware, and all the things were mentioned in the contract at the time of which they were signing their contract. It's mean they were aware about all these things. In spite that he signed their contract. Your Honor, last but not the least, the contract termination clause only activates after 24 months delay. But he breaches the contract after 12 months. Your Honor, if the court is granting me permission, may I proceed to the issue number 3? Issue number 3, where Ali Raza right as a consumer have been violated under Pakistani consumer protection laws. Your Honor, Ali Raza right as a consumer right of Islamabad Consumer Protection Act 1995 have not been violated as a matter pertains to jurisdiction of Islamabad Consumer Court under the provision of Consumer Protection Act. Your Honor, furthermore, the defendant maintains that it remains committed to fulfilling its contractual obligation and is willing to offer refunds if required, which constitutes and required remedy under the circumstances. Your Honor, if the court is satisfied, may I proceed? My co-counsel will address the rest of the 3 issues. Please.
Honorable judges, with great permission, may I proceed with issue number 4?
whether the defendant can successfully invoke the force majeure clause to justify the delay in fulfilling its contractual obligation. Your Honor, I respectfully submit that NREC has the right to invoke the force majeure clause to justify the delay in fulfilling its contractual obligation. The delay in the project were caused by external regulatory hurdles, particularly the required to obtain environmental clearances from the Environmental Protection Agency (EPA), which were beyond NREC's control. These regulatory delays fall squarely within the scope of the force majeure clause, which explicitly covers delays resulting from unforeseen events. External factors. Under Section 56 of Contract Act 1872, a contract becomes void if performance is rendered impossible by an event that is beyond the contract of the party obligated to perform. The NIC was fully aware of the need for these approvals at the time of contract execution, but the delays were due to factors entirely beyond its control.
Okay, which event happened?
Some environmental issues,
Like,
water issues, some nuisance light issues.
are these unforeseen events?
Yes, sir.
Like supply of water, or flooding of water? क्या मतलब है?
Like force majeure. Force majeure.
क्या उसमें water में क्या flood आएगा?
Environmental clearances are not.
There are things which can be foreseen by ordinary people. Like if I'm building something that I have to keep in my mind that there must be some kind of common things. Like supplying water or flooding of water,
Some government
windstorm, these are common, these are not unforeseen. These are
The delay is direct result of external factors fall within the force majeure provisions, as the such NRC cannot be held liable for the delay. Honorable Court cited 2021 CLC 761 and 2021 PND 453. May I request to balance please? The force majeure defined as event of effect that could be neither anticipated or controlled, especially an unprecedented
5 minutes.
event that prevent someone from doing or completing something that she had agreed officially planned to do. Force majeure include both nature or floods and acts of peoples like strikes, wars, refer to the events beyond control of parties which prevent one or both of them from performing their contractual obligation. And such clauses generally focus on impossibility, impracticability, illegality, but parties may negotiate it like any other term of a contract and interpretation.
Then what's the force majeure in your cases? What causes the delay in getting the license or the NOC from the EPA?
Force majeure, some environmental
Yes,
plans
force
are
majeure
not-
is clear to me. But what was that cause which causes delay in getting the license from EPA? Would you proceed on?
Doctrine of impracticability and performance excuse performance by contracting party because happening of event unforeseen by parties destroyed value performance of object of contract. Furthermore, my lord, NIC reliance on force majeure clause is justified and it is not liable for the delay in fulfilling its contractual obligation. May I proceed with question number 5? Whether Ali Reza is entitled to claim damages beyond refund of the amount paid, including compensation for financial and personal losses allegedly suffered as a result of a defendant's breach. Honorable Judge, I respectfully submit that Ali Reza is not entitled to claim damages beyond the refund of the amount paid. There is no willful breach of contract or negligence attributable to NIC. The delay in the project were caused by external regulatory delays, which are beyond the control of the defendant and fall within the ambit of the force majeure. Under Section 73 of Contract Act 1872, compensation for breach of contract is restricted to losses that directly arise from the breach. And the plaintiff claim for financial and personal losses such as lost investment opportunities or emotional distress and cumulative, it cannot directly link to the alleged breach. The delays were not
In other
caused
words, that you admit that the plaintiff is entitled to the compensation or the damages of the remaining amount or whatever which can be refunded to him, but not to the extra compensation or damages which are caused by mental distress or other stuff. इसलिए वो इसका पे भी दिक्कत रहेगी हम इसको कितना damages नहीं भी आप मान रहे हो कि पहले धीरे-धीरे ठीक है अब चलो चाहिए इस तरह है 6 number
whether the plaintiff individual claim for damages should take precedence over or be considered in the conjunction with the potential claim for other affected buyers. Your Honor, I respectfully submit that Ali Riza individual claim for damages should not be take precedence over all claim for other affected buyers. The projected issue is a collective
तो
undertaking.
ये इशू तो दोनों का एक ही इसको स्टक होना चाहिए वो कह रहा है कि नहीं इफेक्ट हो रहे बाकी लोग भी हमारे पर्सनल पर्सन है तो हमारा अपना क्लेम है और हम एप्लीकेशन में आए उसको तो नहीं इफेक्ट कर रहा आप ये कह रही हो तो ये फिर इशू तो बना हुआ है
So issues were framed on the basis of their pleadings.
अच्छा रीडिंग्स में इंडिकेट करते हैं
जी सर अभी अगर ये सांस चेंज करना चाहते हैं तो पोडियम पर क्लिक करें
Because not the one buyer is affected. According to under the doctrine of Paripasu, claims arising from the same set of circumstances must be treated equally to ensure fairness and avoid unjust enrichment. So it is pressed by the defendant and I see that granting individual precedence could lead to the duplication of proceedings, unnecessary delay and an inequitable outcome for other buyers. The defendant therefore proposes that all claims be adjudicated together, ensure fairness, efficiency and uniformity and addressing the grievance of all affected parties.
Is the defendant still willing to perform this contract?
Yeah, please.
परफॉर्म करना चाह रहे हो आगे कॉन्ट्रैक्ट ठीक है ओके बच्चे क्या नाम है आपका
Maria.
अच्छा मारिया
They argued that the defendant that we were bound to do negotiation and we did not did it. Your Lordship, we have attempted negotiation. Your Lordship, a proof of our negotiation is clearly available on page number 2, para 1 of the moot problem, Your Lordship. It states that Ali Raza along with other affected buyers repeatedly requested update from NREC. But NREC cited regulatory delay and rejected their attempt of negotiation and take the stance that it is beyond our control and we cannot do anything about it. Your Lordship, the second question which the counsel for defendant raised that we are claiming consumer rights, so why we did not approach consumer? Your Lordship, I already answered that question, that arbitration was not binding according to the language of the document. Your Lordship, the word may was used for arbitration, not shall, in support of which I have already submitted a case law. Your Lordship, the third question which they raised was about that we are claiming consumer rights, so why we have not approached consumer court. Your Lordship, as I clearly mentioned that we are not claiming consumer right violation, we are claiming breach of contract. That's why we approach this Honorable Civil Court of Islamabad. Your Lordship, the third question which they raised against us that they used the doctrine of caveat emptor that let the buyer be aware. They were right to that extent, Your Lordship, but it must be noted that under the contract, NREC was responsible to obtain environmental clearances before initiating construction. Your Lordship, they have initiated the construction work before obtaining the final approvals. That's why they have breached the contract.
Is caveat emptor applicable in these kind of cases? That is for sale of goods. How would you check goods? Or this is a property, not goods. That is not applicable at all. Secondly, your contract has those warranties expressly written in it. So focus on that thing instead of caveat emptor or other doctrines. Right warranties number one.
Yes, Your Lordship. Your Lordship, to answer your question raised was that why we did not claim specific performance. Your Lordship, we did not claim specific performance. Instead, we
They are
claimed.
willing to perform their contract.
Yes, Your Lordship, but still we did not claim that. The reason behind that is, Your Lordship, that the project is unapproved. Their approval was not granted, and CDA halted their construction and project. So that's why the project is not approved and registered with the government. That's why we are claiming the refund. Thank you, Your Lordship.
The last one. They say that the case should not be proceeded as an individual case, rather the compensation or the case should be considered as a whole.
Yes.
So would you like to proceed as an individual?
Much obliged. Your Lordship, as I've already, as my co-counsel already argued that individual claims should take precedence. The reasons behind that is, Your Ladyship, that each contract between NREC and all bars are separate. So that should be adjudicated separately, Your Lordship. And secondly, Your Lordship, if they are adjudicated collectively, it will consume a great time, and as my co-counsel quoted that justice delayed is justice denied. So that will take a long time, Your Lordship. Thank you.
Would you like to say?
Now the defendant may come to podium and proceed with sure rebuttal.
Your Honor, may I have permission to rebuttal? Thank you, madam. There is a question between from the plaintiff side, and there is a no negotiation. Your Honor, there is also there is written in the clause 8 of the contract that is dispute resolution. It is mentioned that if anything is happening during negotiation at that class of the contract, they are totally ignored by the plaintiff side, which shows that they are breaching of the contract. If something is written in the contract and they are agreed to sign their contract, it means they are all aware about their terms and conditions. If they are not following their terms and conditions, it means that they are ignoring their terms and conditions, and they are simply the breach of contract.
Can you mention the date when this negotiation took place? Either it fulfilled the 30 days gap or not?
Your Honor, at the time of contract, we have mentioned that if something is happening between the parties, then we will be going towards negotiation.
Yes.
If the result is not arising from that and the solution is not arising within 30 days, either may party go towards the arbitration council.
But they say they have negotiated with you people.
No, ma'am, if they have some proof that they are giving us the notice for negotiation, then we can. But they ignore because they are directly filed the suit in civil court. They didn't give the negotiation. And we have mentioned that if something is happening, we will negotiate with each other.
Do you have any proof of the negotiation? Any notice?
Your Lordship, as I've already mentioned that negotiations were done, Your Ladyship, it is clearly mentioned on page number 2, para number 1 of the moot problem, which was available here. Moot problem. Moot problem, page 2, para number 1. Page 2, para 1 state that Al-Yuza, along with other affected buyers, repeatedly request updates from NREC, but NREC cited that the delay is beyond their control. The second point to be noted, Your Lordship, is that they raised the question about 1 month here. Your Lordship, the defendant, the plaintiff also wait for that time and attempted the negotiation. It is evident also from the moot problem on page number 1, last para, it is mentioned that on 1st March 2024, it came to the knowledge of Ali Raza that CDA issued a notice to halt their project. It came to his notice on 1st March 2024, while he filed the suit in this Honorable Islamabad Civil Court on 1st May 2024. There is a gap of 2 months between it, Your Ladyship. So we have attempted 2 months in negotiation. Much obliged.
Your Lord, there is we have written application to NREC on January 1st, 2023, and the agreement between us took place on 1st January 2023. It's mean that we have already strived for that, and we have a lot of we have the application and re-application, and their sites or their team visited also to the inspection team to check all the requirements which are necessary for the certificates. And we have written that, and after that the EPA doesn't give us the again of the replay of re-application. That's why we were waiting for them to give us the replay. How should we can say that? How should the plaintiff say that?
Were you authorized to start construction before getting the approval from?
Yes, Your Lordship. It is mentioned in the class 5 of the contract at the delivery and position. It is already mentioned that if the event on unforeseen regulatory delays exceeding 12 months, the plaintiff should request to the defendant. They are not requested us that directly file the suit. And the second thing is that they continue if they are willingly to continue, and the NREC was willing to continue, and they were bound to give the complete position within 24 months.
5 number last one, you deliver position first paragraph.
The seller agrees to deliver position of the plot to the buyer within 24 months, and it was already 24 months, and the date of signing contingent upon receipt of all necessary regulatory and environmental clearances. The environmental clearances.
Receipt of.
Yes, Your Lord, it was mentioned that in the time of contract and the subsection 8, the clause 8 of the contract.
We have contingency receipts or clearance for contract contingent clearances or receipts.
Your Honor, it is the contingent upon the receipt of all necessary regulatories. And if you look upon the class 8 of the
Your Honor, last part मेरा first name ने लिखा है contract में कि ये contingent होगा upon receipt upon necessary regulatory and clearances. ये delivery of position contingent है या फिर contract contingent?
Yes, Your Lordship, the delivery of possession is contingent within 24 months, that they will deliver possession within 24 months.
It means कि अभी agreement पूरा नहीं हुआ.
Your Lordship, but also Your Lordship, if we see class 3 of the same paragraph, it said that in the event of regulatory delay exceeded 24 months,
Class 2.
yes, Your Lordship, class 3 of para 5, contract para 5 class 3, whose title was delivery and possession. Its third class stated that Your Lordship that the delay exceeded 12 months, we have a remedy to request a refund. That's why we are requesting the refund, Your Lordship.
Very nice.
The court is adjourned. Now you can rest for 10 minutes, and after that the second match will be held.